Hello, my name is Vanessa Zimmerman. I'm a legal advisor to John Ruggie, who is the UN Special Representative on Business and Human Rights, and also a research fellow at the Harvard Corporate Social Responsibility Initiative. But today I'm speaking in my personal capacity, so my views don't represent either organisation. One of the key things I'd like to talk about today is recent developments at the international level on business and human rights. Many of you may know about the appointment in 2005 of John Ruggie, who is a Harvard professor by day and increasingly all of his other time is taken up as UN Special Representative on Business and Human Rights. Professor Ruggie reports to the UN Secretary General and also to the Human Rights Council, and he's tasked with advising the United Nations on the role of both states and companies in dealing with business and human rights challenges. In 2008, he came up with a policy framework for taking the business and human rights agenda forward. That is the Protect, Respect and Remedy framework. It looks at the state duty to protect against corporate-related abuse, including through regulations, adjudications, policies, the corporate responsibility to respect, which is essentially a do-no-harm standard that asks companies to act with due diligence to avoid infringing on human rights. And there's also access to remedy, which really acknowledges that even with the best laid plans by companies and governments, things can go wrong, and there need to be provisions in place through states and through companies to redress issues of human rights abuse. This framework is actually the first framework or standard that has been officially endorsed by the United Nations Human Rights Council. There has been significant uptake by businesses, by governments, by non-government organisations, and statements of support from the International Chamber of Commerce, from a large variety of NGOs, and from governments. The step forward is that John Ruggie has now been tasked with operationalising this framework, which basically means providing concrete, practical recommendations on how to actually operationalise the different pillars of the framework. So what can governments actually do, what can companies do, and what could happen in a remedial situation. John Ruggie's mandate finishes in June 2011, so we've got a big year ahead of us in terms of looking at that practical guidance. And for companies in particular, that means for us looking at the due diligence process, unpacking what it means. We've suggested that as a starting point, it includes having a human rights policy, assessing human rights impacts, reporting on human rights impacts, and integrating a human rights policy throughout the company. And at the moment we're dealing with the challenges that are ingrained within that, which is different sectors, how might different sectors approach these issues, dilemma situations, what do you do when national laws conflict with international standards, how do you balance rights, what do you do beyond respecting rights. So there are a lot of issues there, a lot of challenges. But we're very pleased to have the support and the engagement of a wide variety of stakeholder groups in this project. Thank you.
What would you say to people who say that human rights is really a government issue, it's not a business issue?
Right. Well, at the international human rights law level, it is states that have primary duties under international human rights law. Companies technically do not have any direct obligations. But through societal expectations, through what companies have said they expect of themselves, through international business associations, we've seen that human rights is very much an issue for business. It's something that does affect their bottom line in terms of reputational costs, legal costs, operational disruptions, and that companies are increasingly expecting of themselves at least that baseline standard of respecting human rights. So it's really no longer just the purview of governments. And I think NGOs really prove that, and other advocates, by really bringing companies to account for some of their activities, whether it's on the web or in a local newspaper or through a shareholder meeting. These issues are coming up on companies' radars and really can't be ignored anymore.
In terms of bringing companies to account, do you think the trend is towards holding international companies accountable to the impacts they have in all of their countries of operation? So, for example, the US Alien Tort Claims Act, is that something that you think is being promoted, that approach?
I think that it's definitely being used. We've seen an increase in cases dealing with companies in the last 20 or so years. There have been, I think, 3 major settlements in cases like that for big money in some situations. And so there are a lot of people that are thinking of using the Alien Tort Claims Act and other judicial solutions, but there is also a focus now on non-judicial solutions, on companies having their own grievance mechanisms at a local level, on voluntary initiatives, providing some kind of mechanism to try and prevent systematic abuses and also hold individual companies to account in that way. Also through intergovernmental things like the OECD guidelines for multinational enterprises have national contact points that can hear complaints there. So there really is now, I think, getting to be more of a spectrum of ways in which people are trying to hold companies to account. And I think the shareholder aspect is quite interesting now. So Google, Yahoo, Newmont, Chevron have seen these types of issues being brought up at their annual general meetings, and it's a way for the shareholders to ask questions there, perhaps on behalf of communities or in some cases because of their own concerns as socially responsible investors.
And have some of the standards that have incorporated human rights, like the Global Compact and now the new ISO 26000 standard, been effective? Have we seen them being used? Have we seen behavior change as a result?
Sure. I think it's hard to say if there have been behavioural changes, but I think it's definitely the case that they are being used. When a Global Compact company reports on their performance under the Global Compact principles, there are 2 human rights principles there. They are supposed to at least report on that. I think ISO 26000, it remains to be seen how it will be used. The OECD guidelines, which also incorporate a small element on human rights, are being used to encourage better company behaviour. And what we're seeing is that companies around the world are incorporating these standards into their human rights policy. So they're saying, we acknowledge the perhaps Universal Declaration for Human Rights, but we also subscribe to the principles in the Global Compact. And we may see the same thing with ISO 26000. It's unclear though.
Good. Let's hope so. Thanks very much.
There we go. Thank you.